You do have one cash asset that will never go into your revocable trust. It always gets controlled separately, and there's a very specific way you want to do that. My name is Philip Roos. I'm an estate planning attorney in Minnesota. And you've got all these, if you take out your revocable trust, I like to tell people about my Ziploc bag. You always make sure your stuff ends up in the family trust. You want your house in here. You may want your life insurance and bank accounts to have a pay-on-death beneficiary that doesn't name a person. My life insurance policy, I could list my wife as getting the money if something happens to me, but I don't. I list our revocable trust plan as getting it. I die, it dumps into my Ziploc bag. When my wife goes, it's zipped up, you know. She would get the money if she's around. If not, it goes to the kids, etc. So most of the stuff, almost everything you have, you really want to direct into this thing, and that way you skip probate, and that's why we like revocable trusts. Probate is the administrative court proceeding where we have to go to court and get my stuff divided up if we don't do something to avoid it, such as have a revocable trust. But your IRA, your 401k, your 457, 403b, whatever it might be, your TSP plan, these tax-deferred retirement accounts, they are individual retirement accounts. That's what IRA stands for, of course, and they can't be owned by anybody else but you. So you can't retitle these. You can't take your name off your IRA and put your trust's name on the IRA, which means your pay-on-death beneficiary is going to be very, very, very important. You do not list your estate. You do not list a trust as the primary beneficiary of these. You universally want to name human beings if you can. The reason for this is if you name a spouse and certain other individuals, they can take this money out slowly over their life and pay just a little bit of tax at a time. If you name an adult child, for example, they can have 10 years to take out a little bit of it at a time and pay less tax. If you name my estate, if you name the Philip and Mary Roos Revocable Trust, it's 5 years. And at the 5-year point, they have to take out the whole thing. So there's potentially a lot of tax due. We don't want that. What we want to do is name humans if we can, unless there is a very good reason to not give it to a person, such as a minor child. So I have some little kids. If I want my money, my IRA, to go to my little kids, I have to name their specific section of the trust. So for example, the Article 4.2 trust of the Philip and Mary Roos Revocable Trust for my daughter's name, my other daughter's name, etc. And that's how you do it. Your attorney can work with you through all of that. But bear that in mind. IRAs, don't dump them in the trust. You can't retitle them. You have to do it a specific way, and your attorney can work with that. Any questions on this, obviously, shoot me an email.